I might as well, in the interest of time, get mine started. What I am is the warm-up show for ATF Mark Kelly. What I do is set up something for him to talk about, because he's the guy you want to hear from, right? Everybody hear me in the back and all that? We're good? Okay. My presentation's called "Do the Feds Give a Bean?" This is a very, very slim slice of gun law, federal gun law, and it has to do with folks who have gotten a federal felony and get their firearms disability under the federal law, and then trying to get their firearms rights back. Mostly concerned about nonviolent ones. You know, what if some guy did something a long time ago? So anyway, I actually had a client. We're going through this process right now, and he's perfectly said it's fine to talk about him, use him as the poster boy, etc. So if you see him, this is him. And what we were able to do a month or so ago, I was hoping to have Robert Merting there with me, but we got called up. We wanted an appointment with Trey Gowdy, and for months and months and months, this went on trying to get an appointment. It was just, boom, when they tell you to get there, you better get there to Spartanburg and get there to your appointment. That's what happened. I didn't even get to have Merting there. Anyway, this is the client, Gary, and Representative Gowdy. He was a very good guy to work with there and talk with, very accommodating. We enjoyed it a ton just being in his office. What did Gary do? Well, not the best client to have for as far as what perception of the client is. He's an electrician back in the 70s. He had his own business, and he was arrested and charged with false and fraudulent income tax return. Federal charge under 267201. Now, mind you, this was 35 years ago. Gary was discoing around that time, okay? That's how long ago this was, that he's still dealing with this issue now. He was able to plead nolo contendere. He never admitted to it, but he pled. And what was the outcome was a jail-type institution for 60 days, and then I believe it was 3 years probation after that, and then 3 fines of $2,500. My guess with these three, I never talked with them about it, but they probably charged him 3 years in a row, going back 3 years of taxes. I don't know. What was the local jail like? Well, it was in Michigan, and basically what they did is immediately put him on as a trustee. I'm not sure how much time he actually spent in jail. He said they loved having him there. They used him to do electric work all over the county and all that stuff. And he had lunch, I think, a couple times with the sheriff and all that. So anyway, after 3 years, after 60 days of that, and then after 3 years of probation, he was able to be done. And what he received was a discharge from probation. So his dues were paid, right? Well, so let's do the math on this thing. He's got a felony conviction, which equals, just because of that felony conviction, whether state or federal, he's got the firearms disability. Minus, he paid all his dues, he got discharged. Equals still the same thing. We still have it. It doesn't matter that he was discharged from all that. He still comes out of it with this disability. And for him, possessing a firearm is a felony. It's a new felony. If he's just caught, which I think a couple times you'll hear Mark talk about it, whether they're going around looking for people just to violate this one thing. But if he got caught and if they wanted to make an issue out of it, it's a felony. How do you get rid of that? You've got to get executive clemency. For states, if you have a state felony, we're going to go through the state system. And that is, going back here, that's the Department of Probation, Pardons, and Parole. They have a website. It's pretty easy to see how to do this. But it starts with a application for pardon. And, yeah, I mentioned here, one of the big things for firearms law attorneys is getting this thing right here. It's the reason for requesting a pardon. You do not have to put that it's for firearms rights. You could just say he wants to be a full member, he's paid his dues, all that. You don't have to put anything about firearms in there. You get letters of support from all your old buddies and cohorts and all that. They do an investigation, and it's a $100 application fee. And then you wait 7 to 9 months after the application to get, after their paperwork is received, and then you get a hearing. And if you get restored, you get this following list here of rights restored. Notice that the gun rights are not on there at all. The right to register to vote, the right to vote, serve on a jury, hold public office, blah, blah, blah. But it doesn't include firearms. And I put, why not? That's actually a question I might have to talk more about with Professor Merkel. Is basically, is a person under this statute losing a civil right, or are they just under the burden of a statute saying that you're not able to possess? And I don't actually know the answer to that, so maybe Professor Merkel or Mark can talk about that. Where do we get the authority to say if we go through pardons and all that, that it will be lifted from the firearms disability? Well, in the Code of Federal Regulations for ATF, they say so. They base it on the statute, and they say if a state felon goes through this state process, we're going to consider them to have the prohibition removed. And what it says is that the governor or other state authority, again, our state, the authority is that board. The one caution you got to deal with coming out of that board is if that board says we expressly prohibit. Okay, that's better. That board can come out, you can come out of that board with them saying, yeah, we pardon you for all this other stuff, but we specifically take away, we specifically prohibit the firearms possession. Federal law allows them to do that, and if they do that, then you can come out of all that even with the firearms prohibition. And as a side note, of course, if you got a guy who's got one of these charges, if they want to hunt or something, they can use muzzle loaders, shotguns, muzzle loading pistols, black powder type guns, and there's an attorney general opinion about that. Okay, what about a federal felony? Well, it's a big problem for federal felons. We go back to the same CFR, and it says a pardon granted by the President of the United States. That's one way you can do it. What are the odds? Well, just the latest president, we've got, just for pardons, you've got applications of about 2,245, 66 so far. And that's probably the size of a presidential state dinner, you know, of donors and friends. I don't know how that works, but, you know, 66, that's not great odds for you and me. But what you do is go through the Justice Department, through the Office of the Pardon Attorney. Is there any other way? Well, in theory, yes. You can apply for relief under the statute. What statute is that? 18 U.S.C. 925C. And it says there's an application process in the federal statutes. And it says that if you go through this and the ATF does a background check on you, if they say you're otherwise okay, then you go ahead and get your rights restored under this federal system. If you're denied, then you can take that matter up with the district court. But the problem is that even though this statute exists, every year since 1992, ATF's line item budget, in the budget part of all this, the funding of it every year, it says specifically, we prohibit expending any funds to investigate or act upon the application. So they create a statute, they create an avenue of relief, but they say to ATF, you're not allowed to process any of these applications. What you end up getting is just a denial letter saying that they can't process it. I mean, I'm sorry, that you won't get a denial, you get a letter saying they can't process it. All this is just to show you that this is the latest 2016 budget. You can get it online. And the text of it is, none of the funds appropriated herein shall be available to investigate or act upon applications for relief from the federal firearms disability. So what's going on here is Congress put a carrot out there, and in the same old Congress is saying, but this, you don't have this ability to do this thing. And you know, it's just a political equation at this point. From a legal standpoint, you know, the question is, are they basically nullifying what they did by not allowing funding? Need some? Oh, okay. Yes, okay. State Representative Chumley, and it looks like my state rep Burns is here too, right? Thank you. Yeah, good afternoon. We're going to have you guys say something in a minute here, all right? If you want. Or is Congress saying, we're not trying to nullify this, we're just trying to dump this on the district courts, because after all, you do have the ability to go to district court if you've been denied, right? Well, people have tried that. They've put the applications into district court, and it's gone all the way up to the Supreme Court, the issue. And the issue, the case is U.S. v. Bean, and again, the same old thing. The applicant applied, but he was denied. The letter said, we're not going to process this. It wasn't ever denied. If you know anything about administrative law, which I know a little bit about, remember you have to exhaust all your administrative remedies before a court will say, we have jurisdiction to deal with your issue. So your administrative remedy was to go to ATF and have them do an application for you. Once you exhausted that and they've denied you, then you have jurisdiction in the district court. The court has jurisdiction over your case. The question is there ever a real denial? And the Supreme Court said, no, there was never a denial. You can apply, and they can say, we're not going to process this, but it's not a denial for administrative law purposes. The other issue was what I just talked about. Did Congress intend to just shift the matter to the district courts? Well, it said district court cannot grant relief on its own absent an antecedent actual denial, blah, blah, blah. It's the same thing. I was actually able to get part of the deliberations in Supreme Court on this, and usually it's just tape, but this time they had it on video. But isn't it just, aren't they just chasing their tail? There he goes. I mean, there's really no. Anyway, let me get this back off here. Yeah, and it's just delayed and delayed and delayed. It's never denied. And you got to read I mean, actually you don't, but going through the opinion on this thing, they were actually getting to things like the Tennessee Valley Authority and all this. They went so complicated into this thing when it's really simply, it just seems like they just didn't want to fool with it, really. Let me make sure I get this thing right. Okay, so where does that leave us? I pulled this off of a law review article, but it says so long as the annual appropriations ban remains in place, the director may continue to, quote, not act on applications due to the appropriations ban, and the substantive relief tantalizingly held out by Section 925C will remain beyond the grasp of applicants. What can be done? Well, you can encourage Congress to eliminate the ban, and you can have your client apply for a presidential pardon, and after all, that is free. There's no fee for that one. If you want to read any more, there's a very good law review article on it. It's in my materials, and this covers everything you need to know about this issue. And thank you for letting me come up here, and now you get to enjoy Mark Kelly. Oh, we might have a question. We might have, oh. Okay, oh yeah. Can y'all come up here? How's the temperature in here, by the way, okay? Or let us know if there are any problems with that.